Next, I would like to invite Commissioner Paul Lindwall from the Productivity Commission to come and speak about the Productivity Commission's Right to Repair inquiry. And I'd like to also acknowledge Commissioner Julie Abraham, who's here as well. So thank you very much for both coming.
Well, it's the productivity, and hello to Julie too, and the team is here too, who can speak to anyone during a break, of course, at lunch, for example. We're a sister statutory agency, hello, yeah, Mark, and to the ACCC. We are an advisory organisation of the federal government, and this was our draft report which we put out recently. Thank you very much, Leanne, for inviting us here, and it's great to have the Repair Summit, and I'm glad we'll mostly be able to be part in person too. I'd also like to acknowledge the tremendous work of the team, and in particular the number of them here today. They've worked conscientiously for the report and to the final report, which I'll touch on as we're going forward. The Right to Repair inquiry has been fascinating with many dimensions to the topic. We released our draft report on 11 June and are inviting submissions with a response to the draft by the 23rd of July. Now, we're fairly flexible about that, so if it's a bit later, it doesn't matter too much, but that's the date anyway. We're holding public hearings later in July. We had planned to hold one in person in Sydney, but we can't do that now, so we'll hold in Melbourne, Canberra and Sydney virtually, and we welcome any people to participate as they wish. We then send our final report to the government by the 29th of October, and it has up to 25 parliamentary sitting days to table the report. And the government then, of course, decides whether to adopt our recommendations or not. In the draft report, we pose some initial views and outline where we do not yet have sufficient evidence to make a call on a recommendation. The latter form information requests, and we also expect to hold some roundtables to discuss specific areas of the report. Most of the draft recommendations, I think, can be characterised as no regrets policies, those which should be done anyway. They're worth pursuing. If I could summarise the concerns that led to our inquiry, they'd be this. 1, it's become increasingly difficult and expensive to effect a repair on a broken product, and there is a lock-in to authorised repairers. 2, spare parts are not available. 3, products are not designed to last and fail early, and consumers tend to buy new products rather than have their old products repaired, and there's been a proliferation of e-waste. But these are broad generalisations and don't always apply. In this inquiry, we've examined the evidence from submissions and our own research, and also had looked at the experience and policies of those countries overseas that have implemented a right to repair in one form or another. But what is a right to repair? There are a lot of definitions, we've heard a few today, floating around, but for the purposes of our inquiry, we've settled on this, and it may change for the final. A right to repair is the ability of consumers to have their products repaired at a competitive price by the repairer of their choice. Note that this does not mean that a consumer has the right to have a product repaired at any cost. We need to balance competing interests, those of consumers, manufacturers, retailers and governments. For example, if my halogen light, if I had one, failed, it would be prohibitively expensive to have it repaired rather than to buy a replacement LED light. So in this report, we've examined policies across a range of areas: product obsolescence and design standards, consumer law, competition in retail repair markets, intellectual property and e-waste. And I'll touch on these as we go. The broken phone there is of the PC chair, Michael Brennan's phone, and it's a common occurrence to many of us, I'm sure. Why do some products last many years while others break quickly? Some are easy to repair, others virtually impossible. The cars in Cuba, many dating to the 1940s, are lovingly maintained by their owners, often family heirlooms. I visited there a few years ago. As you travel around Cuba, you'll see men hunched over cars, repairing engines and fixing exhaust systems. Since the country lacks replacement parts, the locals are extremely crafty and adept in their repairs. Cuban ingenuity has kept these old cars on the road. Mechanics find ways to use imperfect parts and keep things running. In Australia, the CEO of the NRMA, Rowan Lund, recently wrote, "Australians are notoriously slow at upgrading the family car. At 10 years, the average age of our cars is second oldest in the developed world." But shouldn't we be proud of this? Is it better that consumers switch over their cars in less than 10 years? We expect a washing machine to give more than 10 years service, and yet a car should be less than 10 years? Not so sure about that. We replace products for a whole range of reasons. It could be the product is broken and it's more expensive to repair than to replace. It could be that the new product offers features that we desire, or the new product is more efficient and less environmentally harmful. It could be that we like a change for the sake of fashion. The design of many products today has incorporated solid-state technology, including the Internet of Things, allowing our products to be connected and controlled remotely. This has been an important factor leading to the rapid changeover of certain products. But why do Pont du Gard, the bridge there in south of France, and the pyramids of Giza stand after so many thousands of years? It's because they were built by trial and error, over-engineered, if you will. The Roman bridges and Egyptian pyramids that were not so well constructed have collapsed long ago. Today, we can design products very precisely using the minimum materials needed for a particular product. The products are then made in a factory in a very consistent and predictable way. This has led to an increase in the mean time between failures of well-designed and well-built products, and also a narrowing in the variation of that mean time between failure. Yet products fail and break. But frequently they are being replaced because of continuing rapid technological innovation. We, the consumer, are replacing our products before they fail. Do we replace products needlessly? Yes, and I'm as guilty of that as many of us. Am I brainwashed into buying the new phone? I don't think so. Overall, we didn't find clear evidence that manufacturers deliberately design products to fail earlier. That doesn't mean that that doesn't happen, and that some manufacturers may do that, but systematically we didn't find evidence for that. Perhaps there might be merit, however, in some labelling scheme to help consumers understand how easy it is for their product to be repaired and its durability. France has such a labelling scheme, and we are investigating this further for the final report. Move on to consumer law now. Australian consumer law provides extensive and comprehensive guarantees, but the guarantees are not well understood and they can be difficult and costly to enforce. It's important to separate the manufacturer's warranty from the consumer guarantee under Australian consumer law. Warranties cannot supplant consumer guarantees, despite some misunderstanding to that effect. The rights a consumer has under the guarantees are for a repair, replacement or refund, depending on the nature of the failure. The ACL, the Australian Consumer Law, provides that a product will have reasonable durability, but it doesn't define what that means. This leaves consumers, manufacturers and retailers being unsure and can cause confusion. In 2019-20, the ACCC reported over 37,600 complaints about consumer guarantees and warranties. So we think there is scope to improve the understanding of consumer guarantees and make it easier for consumers to enforce their rights. So with 3 draft recommendations in this space that we think will help, or expect will help. First, we think the ACCC should develop and publish estimates of minimum expected durability of products within major categories of common household products. We expect that this would help consumers, retailers and manufacturers better understand what a reasonable durability for such products might be. We also think that the ACCC should develop this guidance in consultation with relevant state and territory consumer regulators, consumer groups and business groups. Second, we think that there is scope for an extension of alternative dispute resolution schemes to better resolve complaints, and we cite 2 examples, one in South Australia and one from New South Wales. And I noticed Shane Rattenbury this morning mentioned that there'll be enforceable conciliation introduced in the ACT within the next 6 weeks. ADRs, alternative dispute resolutions, can help consumers enforce their rights without the expense of going to court. Third, for systemic issues, we think that a super complaint system, which allows complaints from recognised consumer groups, could be made to the ACCC, and for these to be fast-tracked and responded to by the ACCC will help where there's an issue of widespread concern. Additionally, we've received many submissions that express concern about the availability of spare parts, you've heard that already, and software firmware updates. We're inviting further evidence to inform just how far we should go and whether there would be a net benefit in mandating manufacturers to hold spare parts for minimum periods, as well as whether software updates be provided by manufacturers for a reasonable period of time after the product has been purchased. Holding spare parts is costly, so is providing software updates for products no longer manufactured. But so too is it costly when a product cannot be repaired for the sake of one spare part. It's a balance, and that's why we're asking for more evidence. As an aside, the increasing use of 3D printing may offer a less costly way of providing spare parts in the future, just as we now see an increasing use of print on demand for rarely purchased books. In 2018, there were about 57,000 repair and maintenance businesses and over 203,000 workers. The repair sector generated about $35 billion in sales revenue. It's probably not surprising, as we heard earlier, that the largest repair industry in Australia is for motor vehicles. There were 40,000 of them in 2020. They are large, expensive and complex mechanical and computerised products requiring regular maintenance. The next largest repair industry is machinery repair, including for agriculture, construction and mining machinery, of which there are around 10,000 repair businesses. Appliance repair, such as for washing machines, ovens, air conditioner units, water heaters and so on, comprises mostly of small businesses. It's experienced relatively strong growth over the last 10 years, but also some consolidation. Finally, the electronics repair industry for computers, mobile phones and so on is a small part of the sector and has been declining, probably due to the relative cost of repair to replacement. I should also note the growing preponderance of repair cafes, and I spoke to a person over here earlier today about that, one in Canberra. So the repair sector is a mixture of independent and authorised repairers. The common refrain to this inquiry is that the efforts of manufacturers and retailers is to send customers to their authorised repairers and make it difficult for independent repairers. In this report, we discuss the interactions between competition in the primary market, the original product purchase, and in the secondary market, the repair market. A highly competitive primary market can mitigate, at least to some extent, the negative effects of an uncompetitive secondary market. That said, there are several products for which market characteristics, including high consumer lock-in and limited product competition, may mean that competition in those repair markets is limited. For the draft report, we identified agricultural machinery and mobile phones and tablets as products which there's likely to be consumer detriment. We also looked at concerns in repair markets for motor vehicles, construction machinery, watches and medical equipment, and there's a number of examples of those in the report. The cost of repair is driven mainly by labour costs, and this is one reason why many products are often less expensive to replace than to repair, although examples of the difficulty in replacing the screens and batteries of smartphones are manifold. These design features, making repair difficult, are not unique to Australia, and we are a net importer of most of the technology. That said, we're looking at the potential for labelling schemes, as I mentioned before, that exist in France. The labour-intensive nature of repair is such that the relative price of new electronics, and you can see that in the left here, over a 20-year period has declined rapidly in real terms compared to the repair. And that's understandable because it's produced in mass in a capital-intensive form and has fallen rapidly. Aside from potential labelling schemes, there are a number of measures which we propose and wish to examine further to promote competition in the repair sector. And this is about IP. First, should we amend copyright law to provide better access to repair information, manuals, schematics and diagnostic information, which can often be hidden behind technological protection measures, such as digital locks? This could be achieved via a specific fair dealing exception in the Copyright Act for the reproduction of sharing of repair information. Or it could be through a general, broader fair use exception in the Copyright Act, something we recommended in the 2016 Intellectual Property Arrangements Inquiry Report. It's notable that the United States has a fair use exception to its copyright laws. And where repair information is hidden behind a technological protection measure, would allowing repairers to distribute and share tools to circumvent such measures to access repair information be beneficial? That's a question. A step beyond such intellectual property options would be a positive obligation on a manufacturer to supply spare parts, diagnostic equipment and repair manuals to independent repairers. And if we went that far, to which types of products should that apply? What that obligation? We don't make a recommendation on such a copyright and positive obligation options in the draft report because we need to ascertain that there will be a net benefit from doing so. We need to examine potential unintended consequences and the effects of such proposals on the primary and secondary markets. Warranty terms. Under Australian consumer law, the consumer guarantees are not voided if a consumer has their product repaired by an independent repairer. However, manufacturer warranties can include terms that void the warranty after any independent repairs or if aftermarket parts are used. We examined a number of warranties and found several examples of these voiding clauses. But warranty terms cannot displace the consumer guarantees. To make this clearer for consumers, we've recommended that there be additional mandatory warranty text which would clearly state that the entitlements to consumer guarantees under consumer law do not require consumers to use authorised repair services or parts. A step beyond this, which we canvass but do not yet recommend, is whether a provision such as the US Magnuson-Moss Warranty Act should apply in Australia. That is, manufacturers would not be able to void warranties if a consumer used an independent repairer. I'll now move on to the final part about e-waste. As Shane Rattenbury mentioned earlier, e-waste is a growing problem in Australia as elsewhere as more and more products use electronic components. Its share of total waste is currently less than 1%, but over the past 10 years, the weight of e-waste has grown 131% compared to 41% for general waste. E-waste consists of many materials, some of which is valuable and some hazardous. The range of materials changes over time. However, as product design and regulations change. Fluorocarbons found in fridges and air conditioners, for example, have been phased out. And the products which presently make up most e-waste include such things as cathode ray tubes televisions, CRT televisions, which are no longer manufactured. Sustainability Victoria forecasts that solar panels will comprise around 10% of e-waste in 2035, up from less than 1% in 2015. So it's to point out that what the materials will change over time, and we have to be aware of that. While Australia's landfill management practices are generally effective, clearly if materials which would otherwise end up in landfill are able to be efficiently reused or recycled, they should be. A product stewardship scheme, where a manufacturer or importer takes responsibility for the waste of its products, is one way to reduce e-waste. But a feature of such schemes, such as the National Television and Computer Recycling Scheme, is that they tend to incentivise recycling over repair or reuse. We think that there should be a change to that scheme so that e-waste products that have been repaired or reused count towards the scheme targets. There will need to be design changes, of course, and perhaps even a name change. It can't be a recycling scheme after all then. And it would be important to have a good scheme designed to prevent rotting of it. Australia has a relatively small population with limited e-waste recycling capacity because of its dispersed population and high labour costs. So the scope for large-scale, efficient recycling in Australia is limited. The lack of cost-effective domestic recycling can increase the incentives to stockpile, dump or unlawfully export e-waste. Exporting of e-waste itself is not problematic, provided it is to destinations that efficiently and safely recycle the waste. Australia is a signatory to the Basel Convention on the Control of Transboundary Movements of Hazardous Wastes and their Disposal, but not yet the Basel-bound Amendment of 1995, which prohibits signatory states from exporting hazardous wastes to countries other than the OECD or EU countries. We're recommending the use of GPS trackers, which are relatively low cost and can be used to see where e-waste is ending up. A risk-based sampling approach would be a useful method of focusing on the types of products and supply chains that have the highest risk to unlawful exports. And in conclusion, this draft report, the Commission has sought to address concerns around a right to repair from a number of angles. There's no silver bullet, however, nor will a right to repair solve by itself e-waste concerns. But there are measures which we are proposing and which we are examining further for the final report that would make a measurable improvement to concerns around sustainability. But it also behoves all of us as consumers to be aware of our patterns of consumption. I'm not a fan of buy now, pay later schemes, which is a form of instant gratification. Perhaps further consumer education campaigns might help, but our own behaviour as consumers should be the one that sets a good example. As for the ubiquitous smartphone, did you know that according to a US survey, 46% of those surveyed over the age of 18 use their phone 5 to 6 hours a day? Taking the median, that's over 2,000 hours in a year. That's a lot more usage than pretty much every other product you have. Your washing machine, maybe you use it 150 hours in a year. Your car, maybe 100 hours. If your smartphone lasts 4 years, that's 8,000 hours, and there's only 8,760 hours in a year. So thank you for listening and contributing to the PC report, and I hope to see submissions and also appearing at our hearing. Thanks, Leanne.